on first contact with you, and he was with you for several minutes. He never mentioned marijuana. The only time he mentioned marijuana is when he went to his car. He ran your vehicle the first time, then he ran it the second time after calling someone and saying that he needed PC on the vehicle. Hello. All right, this is set for a motion to suppress. State, are you ready with witnesses?
No, Your Honor. The witness that we need, Officer Lucio, formerly worked for Hollywood Park
Hill Country Village.
Hill Country Village PD, but no longer does so. He now works for Windcrest PD. I did not learn this information until Friday afternoon and was not able to request Officer Lucio to be present. State requests a reset. If the court denies it, we'll dismiss for missing witness.
All right, then what I'll do is this.
Already, we're seeing cracks in the state's case. Their key witness, Officer Lucio, isn't even in the courtroom. Think about that. The entire case hinges on the credibility of this officer, yet the prosecution isn't prepared. The judge gives them until 1:30 to produce him. Here's why this matters. Without Lucio's testimony, the state is essentially building its house of cards on sand. This delay sets the tone. Will the officer's absence weaken the prosecution's credibility? Or are they hoping the DVD evidence alone will carry them through? Tell me in the comments. If you were the defense attorney, would you already feel momentum shifting in your favor?
Case is coming back this afternoon at 1:30. And it's going to proceed at 1:30. So you have till 1:30 to obtain your witness.
Understood.
Thank you, Judge. May I be excused till 1:30?
Yes. We're back on the record in 2024 CR01 versus Simeon Alexander Nevels.
Yes.
Could I have parties announced for the record, please, for the state,
And pursue.
for the defense?
Robert Maurer for defendant, Your Honor.
And are you Mr. Nevels?
Yes, sir.
All right. So yesterday we had a hearing on a motion to suppress. The officer was called as a witness and you were also called as a witness. The state entered into evidence without objection, State's Exhibit number 1, which is a DVD of the stop of the vehicle and also the entirety of the interaction with the officer on the date of the alleged offense. And counsel, if you could give that to the court reporter so they can have it in their record, please. All right, the court reviewed State's Exhibit number 1 last night, and also I reviewed it again this morning to make sure. Well, there's a lot of coming from that room. All right, the court reviewed it again this morning just to make sure that I had everything that I was looking for with regards to State's Exhibit number 1. And also with regards to both the testimony of yourself and of the officer. All right. The court. That's a lot of noise. All right. When looking at the DVD and bearing in mind watching State's Exhibit number 1, also.
This is a huge legal point you need to understand. Under U.S. case law, if an officer claims to smell marijuana, that alone is enough probable cause to search your entire vehicle. Yes, even the trunk. No warrant, no waiting, just immediate authority. That's why the officer's statement about smelling marijuana is a nuclear bomb in this case. If true, the search was legal. If false, everything collapses. The entire case now rests not on physical evidence, but on whether you believe the officer's nose. Question for you. Should an unprovable "I smell marijuana" really be enough to bypass constitutional protections?
Reviewing mentally the testimony of yourself and the officer, this is what the court finds. The stop was a legal stop. The stop was for speeding. On State's Exhibit number 1, you admit to going over the speed limit. The officer informed you of what the speed limit was. You informed the officer what you thought the speed limit was, but you admitted to the 47 miles per hour and I believe it was a 30 mile per hour zone. Then the next question becomes, did the officer have a right to search your vehicle if the officer in fact thought that there was a smell of marijuana? The case law is clear. If there is a smell of marijuana, an officer is allowed to search the vehicle. They are allowed specifically to search the trunk if they so choose to search your trunk. In this case, they searched the trunk and they found what they believe to be illegal substances. So the next question for the court becomes whether witnesses are credible or not. What the court viewed in State's Exhibit number 1, and if someone is objecting to what the court viewed and what the court is about to say, what is in State's Exhibit number 1, please do not hesitate to let the court know. You are pulled over. You're at an apartment complex. You tell the officer that you are there to see your girlfriend. The officer discusses with you, as he has a flashlight looking in your vehicle, the reason for the stop, which was for the speeding, which you agreed you were speeding. The officer asks for your insurance and driver's license. You tell the officer that you have your insurance information on your phone, but you would like to speak with your girlfriend. The officer asks, friend, and you state to him because, and I'm summarizing here, you state with him because your girlfriend was expecting you and you just want to let your girlfriend know what is occurring. The officer tells you not to do that. You continue to look on your phone for your insurance. You tell the officer, I promise you, I do have insurance, but I got the insurance online and I am looking for it. The officer continues to speak with you, and this goes on for several minutes. During that first contact with the officer does not mention whatsoever any smell of marijuana. The officer then leaves your vehicle and goes back to his vehicle and says he wants to check on something. The officer enters his vehicle, and there are phone calls that are coming into him, and he's making phone calls out. On his screen that is in his vehicle, it appears to the court that he is running the vehicle. The court is unable to view exactly what is on the screen because the writing is very small and the video is not great. But when he runs your vehicle, the court sees that there are green lettering throughout the screen. And he's clicking on a button, and as he clicks on the button, the screen continues to go to what the court is assuming the next page, and that is green. He remains in the vehicle. Another call comes in, and then either he sends a call out or a call comes in to him, and he lets them know what's going on, and he says in the phone, I need PC for this vehicle. Then once he requests PC for the vehicle, then I see the screen again, and all of a sudden, the screen comes up with a bunch of red writing. The court is making an assumption because neither party asked what he meant when he said, I need PC of the vehicle. The court is assuming that that call was, I need probable cause for this vehicle. Then after he does that, he gets out of his car, comes back to your car, and he shines the flashlight on you again, and he says, why are you looking at Wells Fargo? And your response to him was, I'm looking at Wells Fargo because that's where my insurance comes out each month. I swear to you, I have insurance. He allows you to do that. Then he says something to the effect of, let me be honest with you. I smell marijuana in your car and you have this box. And you tell him that box is empty. He says, do you have any weapons or anything in the vehicle? Because I'm going to search your vehicle. And your response to him was, I have a samurai sword. Just as a side note, no, but that's what you tell him. So then he says, well, I smell marijuana, get out of the car, I'm searching your entire vehicle. He takes you to the back of the vehicle. He proceeds to handcuff you and tells you you're not under arrest, but I'm doing it for my safety. Then he searches your vehicle. The court is going to find that the state's witness was not credible. And so I'm going to grant the motion to suppress, not based upon the fact.
And there it is, the hammer drops. The judge doesn't just question the officer, he outright calls him not credible. That's brutal in legal terms. By granting the motion to suppress, all evidence found in the car is tossed out. Without evidence, the state's case evaporates, and the reason? The officer's shifting story about smelling marijuana. The judge saw it as manufactured after the fact, not genuine at first contact. This is a textbook example of why credibility matters more than anything in court. Evidence only matters if it was obtained legally, and here the foundation collapsed.
That the search was improper or illegal. I'm basing it on the fact that the officer was not credible when the officer stated that he smelled marijuana in your car. And the reason for that is because on first contact with you, and he was with you for several minutes, he never mentioned marijuana. The only time he mentioned marijuana is when he went to his car. He ran your vehicle the first time, then he ran it the second time after calling someone and saying that he needed PC on the vehicle. The court is assuming that PC means probable cause to search, and he's looking for that and asking for them to give him PC. I could not understand or hear what conversation was going with whatever party he was on the phone with. But if he's asking someone for PC to search your vehicle, that means in the court's mind that he wasn't credible when he said he smelled marijuana. Anything else from either side?
No, Judge.
Yeah, Pro John.
Yes. Thank you.
Thank you, Judge.